There was a competition and market authority, Flynn Pharma Ltd, another, and Pfizer Inc, and another.
Yes. My Lords, the Court has finally given the parties the order of play. I act for Pfizer, and I'm due to finish by 12:15. In the time available, I wish to address my Lords on three matters relevant to the grounds of appeal. First, I wish to draw the Court's attention to the nature of the competition authority, Second, I wish to address the concept of a chilling effect on the authority, and how the Court of Appeal misinterpreted it. And third and last, I want to emphasise the system introduced by the Competition Act and how the Court of Appeal misunderstood that with regard to infringement decisions. So essentially the nature of the competition authority, chilling effect, and then the nature of infringement decisions. So without further ado, could I turn to the CMA itself? The CMA describes itself in its written case, but in order to get the full flavour, I'd be grateful if we could go to page, and I'm going to refer to the core volume if that's permissible.
Yes.
To page 3379. 3379.
Yes, if you would refer to electronic page numbers, other than the key documents volume, we don't have any paper nowadays.
No,
so we do depend on...
So I'm going to concentrate on the core volume wherever
yes.
I can. And so page 3379 of the core volume, this is the CMA's annual report and accounts for the year ending March 2021. And I'd like to just briefly touch on this because it does give a flavour of the CMA itself. So at page 3382, we see the contents of the annual report, the overview, corporate governance report, remuneration and staff report, audit report, and the financial statements. At page 3383, we see the start of the overview, and the CMA describes its functions and objectives, and I certainly do not want to downplay the CMA's objectives, which are to promote competition, prevent distortions of competition, and benefit consumers. Although equally, if the CMA wrongly interferes in the competitive process, markets will not work well and consumers may lose out, and that is why the Competition Appeal Tribunal is there. If we could continue to page 3386, this is still part of the overview. We see that the CMA issued 8 infringement decisions, that is 2/3 of the way down. 8 infringement decisions, resulting in £52 million in fines. It also secured 10 company director disqualifications. We see that 3386. That's under the competition law enforcement, and then personal responsibility for competition law breaches. Just for the sake of good order, at page 3387, we see there were 3 regulatory appeals, and this is not part of the 1998 infringement decision system. This is where the CMA sits as an arbitrator and determines a dispute between a regulator, such as Ofwat, the water regulator, and an aggrieved person. This appears to be confirmed, we don't have to take it up, at paragraph 11 of the CMA's written case at page 140 of the core bundle, but as I say, we don't have to go to that. If we then go to page 3409, we see that the CMA had, in that year, a budget for the year ending 31st March 2021 of almost 100 million, 95.7 million. And the lion's share, we see that on the first bullet, is concentrated on business as usual activities. That obviously includes the adoption of infringement decisions. So it's a fairly large budget. If we go over the page at 3410, again, the last entry is under fines income. We see fines collected, this is not levied, but collected for the year of 56.8 million. So substantial fines. The corporate governance report starts at page 3411, the corporate governance report. And I would ask the court to go to 3419. Again, it gives a flavour as to the identity, the nature of the CMA. 3419, we see the CMA Governance Statement 2020-21. We see the CMA's Board of Directors, and this page shows that the Board of Directors establishes its strategic decision, meets frequently, 16 times a year, considers the financial position, and if we look at the last paragraph on 3419, we see that the Board of Directors has updates on case progress and recent litigation. So litigation clearly goes all the way to the Board of Directors. If one goes over the page to 3420, that's the board membership, and it looks quite similar to a public limited company. There is a chair, there is a chief executive, there are non-executive directors. At 3421, we see that there is an executive director for enforcement. And then, importantly, at 3421, at the bottom, we see that the Board of Directors is advised by its general counsel, it has a general counsel, and its chief economist, who attend board meetings in an advisory capacity. So the decision whether to proceed to an infringement decision is taken clearly after specialist legal and expert economic advice. And underneath, and we see this at the bottom of 3421, underneath the General Counsel sits the CMA's legal service. This, as we know, includes a significant team of specialist competition lawyers. And then over the page, we see the chief economic advisor. He takes advice, or she takes advice, from high-quality advice from the CMA economists and the CMA's data unit. And as that passage there acknowledges, these competition cases are often complex. At 3423, we see the CMA board and its executive committees. One of these, at the bottom of 3423, one of these is a risk committee called RROC. And over the page at 2424, that's in the middle, just above the remuneration committee, we see that the risk committee works closely with the CMA's legal director. So we take this to be all part of the corporate governance within the CMA to assess the risks of a successful legal challenge. The remuneration and staff report starts at 3438. This obviously discloses the salary, bonuses and pensions of senior management, but it also gives the number of staff employed, and that's at 3448. At the bottom, it will be seen that the CMA employs around 850 staff. So it's a fairly large organisation, well equipped with lawyers and economists. Coming closer to home to this case, I'd like to skip the audit report and move lastly to the financial statements, which are at page 3464. These are the financial statements of the CMA. And I would ask the court to note the items on page 3465. This provides for the statement of comprehensive net expenditure. This is called SOCNE. It's a phrase we'll see in a minute, SOCNE. And I wish to refer to a few items relating to income and expenditure, relating to litigation. We see there operating income and we see expenditure. So on the issue of income, can we go to page 3470? 3470, which is essentially two-thirds down. It's under the section 1.4 income. The principal forms of income are income from the CMA sitting as an arbitrator. That's the regulatory appeals. And if we go to 3471, we see that income also includes the appeal cost reimbursed. So the statement says income in the form of appeal costs reimbursed is recovered from parties who have unsuccessfully appealed a legal decision made by the CMA. The CMA accounts for income that relates solely to the recovery of the internal element of these costs. So these are the CMA's in-house costs, as any external costs, disbursements, are offset from fine income on the CMA's trust statement. We'll come to that in a moment, but at the moment we're looking at income, and this is the CMA's in-house costs. The income recognition point for internal legal cost reimbursement is when a court or tribunal judgment is handed down stating that the appeal has been dismissed. The CMA's decision is being upheld and it is agreed or ordered by the court or tribunal that the appellant should pay the CMA all or a proportion of the CMA's costs in the appeal case. It is a matter of record, and we can see this in the rulings below. These in-house costs are assessed by reference to the solicitor's guidelines hourly rates set by the courts and tribunal services. So, for example, we have seen that the CMA has a general counsel and a legal service. So the CMA recovers the notional legal costs associated with their time spent on the case. If we go to page 3476, we see the figure for this income for reimbursed legal costs. That's under 5 income. The CMA recovered 1.12 million in respect of its in-house costs.
Sorry, which page?
I beg your pardon, my lady, 3476. 3476. We see the figure for this income. The CMA recovered 1.12 million for that year in respect of its in-house costs being reimbursed. And we see at the bottom of the page that the CMA received reimbursement in respect of 8 legal cases. In 2021, the CMA received reimbursement for internal legal costs in 8 legal cases that were appealed. So it basically averages out at about £140,000 for costs, for its own in-house costs. Of course, that is excluding external costs. Lastly, I'd like to just point out the expenditure. Again, this is relevant to the issues on this appeal. I refer the court to page 3475, so we go back a page, which concerns the CMA's costs of goods and services. We see a quarter of the way down under litigation costs. So it's page 3475, litigation costs. This is after utilities, service charge, plant machine. We see litigation costs. We see there is a nil entry for litigation costs. And the reason is given at footnote 55. And footnote 55 says the CMA has approval to fully offset litigation costs against Competition Act penalty income, effectively meaning that these costs are fully funded, which consequently results in nil litigation costs being recognised in the statement of expenditure and disclosed in note 4. So nil litigation costs for the CMA because it is offset against penalty income. And we see a further statement in this respect at page 3494. We see the figures at 3494. This is the trust statement. Statement of revenue, other income. Under expenditure, penalty offset to legal costs, 2.06 million. Penalty revenue, 56.78 million. So there is a penalty revenue of almost 57 million, and a penalty offset to legal costs is just over 2 million. And I emphasise the disparity between these sums, and it again is a matter of public record that from February last year, 2021, to February this year, 2022, the CMA has levied in excess of £400 million in fines, over £400 million in fines. And it is entitled to offset any legal costs against that sum. So I wanted to refer...
Sorry, can I just start? Entitled to offset legal costs, is that as a result of a legal rule or just an understanding with the Treasury?
Well, I think this is an understanding with the Treasury, so it would go into the consolidated fund.
Right.
But before it does, they deduct the legal costs.
Okay.
I think that's why at footnote 55, I think the CMA has approval, and when it says approval, I think that's the approval from the...
Right. Okay, thank you.
The reason I wanted to refer, my ladies, to these facts, this report, is I want to highlight 3 facts that flow from it. 3 facts. First, the CMA is a highly organised body which operates according to recognised precepts of good governance in business. Highly organised body which operates according to recognised precepts of good governance in business. Hence, the CMA's use of corporate governance. And as we know, principles of good corporate governance include litigation risk. And the CMA draws on significant in-house expertise, both legal and economic, when adopting infringement decisions. The CMA actively considers litigation risk, assisted by its General Counsel, Chief Economist, and its Executive Risk Committee. It knows, as night follows day, that when it adopts an infringement decision, that company concerned will have to incur costs in defending itself, and I shall come back to that later on. But it is a well-organised organisation adopting decisions, and those decisions will force the person concerned to incur costs. That's the first point I want to emphasise. The second point is the CMA regards as income the in-house costs reimbursed by unsuccessful appellants. It regards as income the in-house appeal costs reimbursed by unsuccessful appellants. And this highlights, again,
Are they separate from the legal costs that you showed us in them?
this is purely, so the second point is purely and simply it's in-house costs.
Yes, but when you showed us a figure of 2 million for legal costs, is that counsel and so forth, or does it include their own?
That as I understand, it's council's costs. So I think again it's a matter of public record. There's a case at tab 79 of the core bundle called Lexon. It was a pharmaceutical case. Lexon lost. The CMA received its costs in excess of £400,000. That would have included an element of in-house costs and external costs.
Mm-hmm. Thank you.
So that 2 million, I believe, has in-house, it would be external costs as well. But the point is, the second point, the CMA regards as income its in-house costs which are reimbursed by unsuccessful appellants. And this is relevant to when we come to the tribunal's rules. It's relevant because it highlights the asymmetrical nature of the CMA's proposed cost rule. It highlights the inequality, the asymmetrical nature of the cost rule. And third point I want to make, and again I just mentioned it, an adverse costs order would be fully offset against the substantial penalty income. And the penalty income far exceeds any adverse legal costs. And that is why the CMA refers to nil litigation costs. And that, in my submission, is highly relevant to the second issue I wish to address the court on, which is the chilling effect.
And that, you say, is that different from ordinary government departments?
Yes. It essentially is being bankrolled by, for example, the £400 million it has levied since February last year. It is entitled to offset any adverse legal costs against that penalty income. That is relevant in our respectful submission to when one comes to apply the rules as a matter of first principle whether the cost rule adopted by the Court of Appeal is a just one. Can I then proceed to my second issue, which is the chilling effect? And this is the concept of a chilling effect on a public authority threatened with an adverse costs order. In our submission, this concept of chilling effect has been an important part of the reasoning in the 4 cases relied on by the CMA and the Court of Appeal to support its approach to costs. I'd like to take the cases in chronological order and emphasise the passages where we see the court being concerned with the chilling effect of an adverse costs order on the relevant authority. And the starting point is the case of City of Bradford Metropolitan District Council and Booth. We call it Bradford for short. And this is at page 1181 of the core bundle. 1181 of the core bundle.
I mean, we'll go through all the cases, but your point is a very short one, really, isn't it? I mean, the only supposed justification for a rule is that it'll put off public authorities if they have to pay costs. And you point out, well, they won't get put off because it doesn't cost them anything.
Correct. That's a very, very short
That's
point.
really, really the long and short of it.
Yes, I mean, quite a lot of the written material analyses the four cases, but I mean, your case is almost a policy point that whatever the merits of such a rule in relation to certain public authorities, there is no justification for it in relation to the CMA.
Yes.
That is the nub issue.
That is the nub issue. Yes. And in my submission, that's not just a reflection of what should be in the common law, the just principle. When one looks at the tribunal's rules, there is a direction that the parties, the authority and the person, should be treated equally. So unless there is some sort of objective justification, good reason for treating them differently, then in our submission, it cannot be a misdirection to treat them equally, unless there is some good reason, for example, the chilling effect. And one can't just presume it. You can't just pitch up and say there's a chilling effect. It's not, and the Court of Appeal has said, and we'll come on to this, it's not self-evident. No case has been advanced by the CMA that it does have a chilling effect. It's completely inconsistent with the reports that I've just shown the court. And so that absolutely is a very, very important of our case as to why there was no misdirection below, where the tribunal adopted an issues-based cost order. And this wasn't just a cost follows the event. This was an issues-based cost order, which is adopted so frequently, both in the administrative court and in all civil courts, an issues-based cost order. So Pfizer, there was three issues: market definition, dominance, and abuse, as my lord will have seen. Pfizer won on abuse, which was quite an important one, and roughly got 58% of its costs, which the tribunal shaved off quite a lot and said it should be discounted on detailed assessment. But in our submission, in the absence of any compelling reason on chilling effect, it's not a misdirection for the tribunal to say, well, the governing principle under the rules is to treat the parties equally. This would be an unequal, asymmetric cost rule if I can't give the successful appellant its costs unless the authority has behaved in bad faith or unreasonably.
You said when we were looking at the accounts that they deduct the costs that they have to pay to the other side if they lose from their penalties. But what happens to their own costs if they lose? Do they also deduct those from the penalty before they pass it on to the consolidate? They pass on the remainder. So if they lose the case, they have to pay the other side's costs, but they also don't get their own costs. Those are two separate sums of money.
Obviously,
I thought you pointed out that both get deducted.
yes.
Well, okay.
I think
On page 3494 was the offset legal costs. That was their own illegal costs.
so.
Is that right?
And the other sides were an earlier entry, I think, 3475.
Footnote 60 on page 3494 says CMA has approval to fully offset litigation costs against penalty income. I rather read that as meaning the full cost to the CMA of litigating,
Yes.
which may be any cost order made against it, as well as its own cost of losing.
that's how.
But can it calculate its own costs using the same guidelines if it's deducting them from the penalties?
It knows if it loses, it knows it won't get its in-house costs. It will have instructed specialist counsel to act for it. If it loses, it will have to pay probably a percentage of the successful appellant's costs, and the costs that it has paid to its own counsel will also be deducted from the penalty income.
It is, right.
That's how I read it, and I'm sure that the CMA will correct.
I'm sorry, I it may be that you did just explain it, but I didn't quite follow. What happens to the in-house legal costs?
Well, if it loses, then I think it just the in-house costs must because it
just pays the people their salaries instead of getting any money back from them.
They have a budget to pay for the salaries. Essentially,
so they can't use this understanding with the Treasury to recoup that element if they lose.
They're already, essentially, the way it's net profit. The income on its in-house costs. It's a notional charge because the General Counsel, as we've seen, is paid a few £100,000 a year. If it a part of that would be the time spent on a case is regarded as a notional charge. If the General Counsel has acted in a successful appeal, it is essentially a net profit.
So here's where we've got to, that if they lose, they can deduct from penalty income any costs that they have to pay to the other side, the successful appellant, and their own disbursements, so their own counsel, expert economist, etc. And their own in-house lawyers just get their salary, and that's paid for from the.
So I understand.
That's right. But if they win, they can charge the other side not only their disbursements, but also their in-house legal costs, calculated, as you say, according to the guidelines. And they then keep that money?
Yes, that's income.
That's income.
That is under the section income. I should go through. I mean, I appreciate the court will have gone through the 4 cases in some detail. What I would like to do, however, is just emphasise where the cases have referred to the chilling effect, because I in my submission, it is a key reason why the courts arrived at the conclusion that they did. So
yes, you're taking us to Bradford at 1181.
1181. And as the court will know, this was an appeal to the Magistrates' Court by Mr. Booth against the council's refusal to renew his taxi licence. He succeeded. The Magistrates' Court renewed his licence and awarded him the costs on the basis of costs follow the event, and this seemed from the judgment to be the starting point and the end point. The appeal by the council was by way of case stated, and the 2 questions asked are at paragraph 9 at page 1184. So that is at paragraph 9 on 1184. First, the magistrates asked whether they were correct in applying the costs follow the event principle, and the divisional court answered no, they were not correct. Second, the magistrates' court asked whether they were correct that there was no requirement to find unreasonable conduct, and the divisional court answered yes, they were correct. There was no requirement to find unreasonable conduct. And we see that the no and the yes answers, we just flip to the end of page 1188, we see there Lord Bingham saying to the questions asked by the court, they would answer the first question no and the second question yes. Going back to page 1184, I know that the court will have read paragraph 10, which essentially sets out the submissions of the local authority, Lord Bingham summarises them. But counsel argued that a local authority should not be ordered to pay costs unless it had acted unreasonably or dishonestly. And on the issue of chilling effect, he stressed that an adverse cost order would be gravely detrimental, he uses the word gravely detrimental, or Lord Bingham does, to the licensing function of the authority. And that is at page 1185, 6 or 7 lines down, on we see he urges that it would be gravely detrimental to the protection of the public if local authorities were to be deterred from making whatever decisions they thought were right by the fear that if those decisions were challenged and if the challenge was successful, they would be mulcted in costs. Lord Bingham refers to these arguments at paragraph 22 on page 1187. And he rejects the authority's submission that the authority should only be liable for costs if it acts unreasonably in bad faith. And then we get the paragraphs 23 to 26, where Lord Bingham sets out the proper approach to questions of this kind. And as we know from BT and Ofcom and many of the other cases, they refer to the 3 principles. There are 3 propositions, 3 principles set out by Lord Bingham. And maybe if I could just ask the court to read 24, 25, and then I would like to draw 4 propositions from what is said in those paragraphs. So this is 1187, 24 to 26. These are important because they are the source of the subsequent cases. So could I set out 4 propositions that I draw from what Lord Bingham said? First, it was permissible to make an order that costs follow the event. It was permissible to make an order that costs follow the event if the court considers it just and reasonable. This is because Section 64 confers a discretion to make an order as it thinks fit and reasonable. But it was a misdirection in cases of this kind to apply costs follow the event in all cases without considering all the circumstances. So the court can make a costs follow the event order, but has to consider all the circumstances. The second proposition I want to make is that the chilling effect on a public authority is one such circumstance. The chilling effect on a public authority is one such circumstance, but it is just one factor to consider. In deciding what is just and reasonable, the court should consider all the circumstances of the case. And we see this from the third principle, paragraph 26 on 1187. The chilling effect is to be considered in addition to any other relevant fact or circumstance. And I'll come back to this when we see it, Lord Justice Goldring's judgment in the Divisional Court. But it is one factor to be considered. Third, and this is important, the chilling effect must be caused by a fear of exposure to undue financial pressure. That is the phrase used at page 1188. This is basically undue financial harm which would deter an authority from making a decision. And Lord Bingham was clearly responding to the authority's submissions about being deterred because that was a submission, deterred from making licensing decisions. The use of the word or the adjective undue means there must be something about the level of costs that would act as a deterrent to making decisions. Lord Bingham uses the adjective undue. And the fourth and last proposition that I wish to make is that there is no requirement that the authority act reasonably or in bad faith before a costs order can be made against it. And the answer to question B is clear. Indeed, if we go back to the opening of Lord Bingham's third principle, so at page 1187, which starts where a complainant has successfully challenged, if we go back to the opening of Lord Bingham's third principle, the issue whether the authority has acted unreasonably or in bad faith is a threshold requirement before all other circumstances are considered. If the authority acts in bad faith or unreasonably, one would expect a costs order against it in any event. The reason for there being no such condition of bad faith or unreasonable conduct, as we've seen, is given by Lord Bingham at paragraph 22 on 1187. If such a requirement were imposed, it would deprive the justices of any discretion to view the case in the round, which obviously is what a discretion as to costs confers. So those are the four propositions I respectfully submit flow from Bradford. Could I go next to the Baxendale-Walker case, the disciplinary case?
Is there any significance that Lord Bingham refers to the financial prejudice to the particular claimant and undue financial prejudice to the public authority?
I do, because it's not just any financial prejudice, because clearly if one pays 10p in costs, then that's a cost. But the adjective undue is essentially a response to the submission made by the council that adverse costs orders would be gravely detrimental. There must be something about the level of costs which is going to deter the authority from doing what it does in the public interest. That is, the undue is that there's something about the level which is going to deter the authority from making the decision. And we see this reflected in the next three cases. The next one is Baxendale-Walker at page 1169. This is Baxendale-Walker. As the court will know, there were two counts of conduct unbefitting a solicitor. One he admitted and the other was not proved. The divisional court ordered that he pay 60% of the Law Society's costs, and his appeal against that order was dismissed. I'll take this quickly. I just want to concentrate on the chilling effect. The costs issue starts at paragraph 27 on page 1176. 1176. Just at the bottom, just so I highlight it. It's H, the costs issue. But it is paragraph 39 at page 1179 that is important. And paragraph 39 is at the bottom, 39 is at the bottom of page 1179, which begins, "In our judgment, Jackson J. was right." And the principle applies, and then if I could pick it up around about B, an order for cost should not ordinarily be made against it on the basis that costs follow an event. The event is simply one factor for consideration. It's not a starting point. There is no assumption that an order for costs in favour of a solicitor who has successfully defeated an allegation of professional misconduct will automatically follow. And then one crucial feature which should inform the tribunal's cost decision is that the proceedings were brought by the Law Society and exercise its regulatory responsibility in the public interest and the maintenance of proper professional standards. For the Law Society to be exposed to the risk of an adverse costs order simply because properly brought proceedings were unsuccessful might have a chilling effect on the exercise of its regulatory obligations to the public disadvantage. So we actually get the reference to the phrase chilling effect.
So that's a difference between private individuals litigating and a regulator like the Law Society, because there's no prizes for coming second in private litigation. If you lose, you have to pay the costs, even if you had a good argument that was ultimately unsuccessful. But here they seem to be saying, if the Law Society has properly brought the proceedings, then that is a factor, even if it fails.
And that is correct, my lady. And I'd go further, because, and we can do this by reference to what the Law Society has essentially submitted in this case, because I think it is important to see what they say. And if we go, and why it is regarded as a crucial factor, if we go to page 236 of the core bundle, 236. This is the case of the intervener, the Solicitors Regulation Authority Limited, and it is quite important to see how high they put it on this chilling effect. And again, I'll just refer to certain passages. Page 242, paragraph 13. The authority said there is a, this is the heading halfway, a real risk of chilling effect on the SRA's regulatory and disciplinary decision making. The policy justification for the Baxendale-Walker approach was accordingly firmly rooted in the clear public interest that important regulatory work must not be imperilled by fear of adverse costs orders. This policy justification is the golden thread that runs through relevant decisions both before and after Baxendale-Walker, which is essentially what I'm trying to say. Paragraph 14, equally, this fundamental concern was emphasised in Perrin-Panathan, and I'll come back to it. But that's paragraph 13, where we see how the Law Society puts it. Paragraph 19 at 244, the real risk of a chilling effect on the Law Society, now SRA's regulatory work, was treated as self-evident by the Court of Appeal in Baxendale and in Perrin-Panathan, too, in respect to the relevant police authority. The SRA is firmly of the view that the Baxendale-Walker approach on costs is essential to avoid the real risk of a chilling effect on SRA decision-making regarding whether to launch a prosecution in the SDT, and if so, on what basis. And then lastly at 246, the next page, paragraph
20 is also important for the point that you were making
it is.
earlier, yes, that they don't have this advantageous...
They're funded by practicing certificates, and that's why they're saying that their kind of income may be not sufficient to offset legal costs, and that's why, if one goes to paragraph 24, there is a compelling public interest in avoiding it. So I think it is important to see why the Law Society is saying what it's saying. But the important point is there's a real risk of a chilling effect on the authority's regulatory functions which we say are simply non-existent on this present appeal. And even they cannot be assumed. The Court of Appeal has said they're not self-evident, and no case has been made for a chilling effect on the CMA.
So your submission, as I understand it, is that if you win this appeal, that doesn't mean that the Baxendale Walker Authority is wrong, or the approach taken in SRA or even licensing appeals is wrong. Is that?
No, we're not submitting that there cannot be a principle which takes account of a chilling effect on an authority. Where it is considered is one can argue, because sometimes it's quite nuanced. But the Competition Appeal Tribunal has, throughout its time, always looked at the chilling effect on the public authority and has decided one way or another. And that's what I want to come back to in my third issue. But we will say that the CMA is in a completely different situation to the regulatory bodies in these cases. I will come on to submit that. But the notion that a chilling effect is irrelevant, it would be wrong for me to say that, because if it does, if the legal costs do deter a public authority from carrying out its duty in the public interest, then clearly that has to be considered. And that actually was the basis upon which the Court of Appeal in BT and Ofcom remitted the matter back to the tribunal.
So your position is that, as I understand it, is that the CAT did not make any legal misdirection because there is no firm principle that you have to have the starting point that the Court of Appeal found in relation to this sort of appeal in front of the CMA, this sort of hearing.
We say there was no misdirection. We do say that. Frankly, we do take issue with what the CAT, the CAT, did, because it ducked the question of chilling effect. But when it came to the Court of Appeal, and we argued chilling effect in front of the CAT, but when it came to the Court of Appeal, all the cards were on the table, and the Court of Appeal was quite entitled to say its chilling effect is not self-evident, which in fact it does do. I think we'll see it at paragraph 100. It says it's not self-evident there is a chilling effect on the CMA. And armed with that view of the world, that it's not self-evident, and in the presence of the CMA not really advancing any case on chilling effect at all, we say, as a matter of principle, in the light of the rules, an issues-based cost order cannot rationally be a misdirection. The third case, and I'm whizzing through them, is the Perrin-Panathan case. That is at page 1267. This was the 15-year-old who was stopped at Heathrow with £150,000 in cash in her luggage. I wish to refer to three passages in the judgment, and again, they show that the chilling effect on the police in this situation was a key part of the reasoning. So I just want to go to three passages. The first is at paragraphs 43 and 44 of the judgment of Lord Justice Stanley Burton, and these are at page 1292, 1292. above paragraph 43, the application of those propositions in the present case, gone through the review of the cases, refers to the three principles in the Bradford case, and then midway between, basically at D, as I've pointed out, they could not detain the cash indefinitely. It would have been irresponsible and a breach of their duty to the public for them to have delivered up the cash to the claimant in those circumstances. The only alternative was to make the application for its forfeiture as they duly did, and that they should not have been deterred from making that application in those circumstances by concerns as to their liability for the costs of the claimant. So again, I don't have all the submissions, but clearly Lord Justice Stanley Burton is concerned about the chilling effect on the police in making the application for forfeiture of this £150,000 that has been found in Heathrow. So that's the first passage I'd like to emphasise.
It's also, I mean, it may also be relevant that when the police find this money, they have to decide there and then, in a minute or whatever, what they're going to do. There's no 3-year investigation.
No 3 years with statement of objections. And either they give it back to the 15-year-old or the mother, or they, if they believe that £150,000 cash is a risk of it being used for unlawful means, they have to go to the magistrate's court to get an order for forfeiture. It is, as Mr. Justice Roth subsequently said in Eden Brown, we'll come to that, the procedure by which infringement decisions are adopted, he really uses the word, not remotely comparable to the situation in this case. So that was the first paragraph. I just want to refer to Lord Justice Stanley Burton. It is important.
It may not be part of the reasoning, but one might think that if you come into the country with £150,000 of cash in a suitcase, it's sort of a hazard that you take that you might have to pay the magistrate's costs before you get it back.
Certainly a hazard. If only you had £150,000 in cash. The second passage is the judgment of Lord Justice Goldring in the Divisional Court, because this submission wasn't just made in the Court of Appeal. So at paragraph 45, Lord Justice Stanley Burton cites paragraph 29 of the Divisional Court, as at page 1292. And again, I won't read the whole paragraph, but one sees the very last line on 1292, where the Divisional Court, Lord Justice Goldring, is saying it would be quite contrary to the public interest if, due to fear of financial consequences, it was decided not to seek forfeiture but simply return the money. The public duty requires the police to make an application in such circumstances. So this was a key consideration in the Divisional Court, which follows through to the Court of Appeal. I would also, when it comes to looking at
the decision that's being made by the police is whether there's prima facie evidence, as opposed to making a final concluded decision, which is another difference.
I would also ask the court to look at the paragraph 32 of Lord Justice Goldring's judgment, which Lord Justice Stanley Burton cites, because it does give the flavour again that the Bradford principles are flexible. They're flexible. They're not a rigid cost rule. Where it says it is necessary to emphasise the limits of what is said in the Bradford case. It is not, as David said in the Chief Constable, Police, with which I agree, setting out any sort of test. The Bradford case merely sets out a series of factors which the court should take into account in the application of section 64, that's the discretion. The court, as Lord Bingham CJ said, may think it just and reasonable that costs should follow the event. It is worth to emphasise in the words, in addition, which precedes subparagraph 1 and 2 of Lord Bingham's third proposition, which is what I referred to earlier on. So it is important when one looks at Lord Bingham's third principle and the words in addition. So it's looking at all the circumstances. The last paragraph in this case is, in the main judgment, is paragraph 53 at 1294. This is the judgment of Lord Neuberger, the Master of the Rolls. At 53, halfway down, he's putting the cases for and against, but he says the police, this is an F, the police for their part can say that it was statutorily charged with the important regulatory function of seizing and confiscating hot money, and that they should not suffer a further financial burden over and above their own administrative and legal costs of carrying out that function in a reasonable way. More broadly, and again we get the chilling effect, more broadly it can be said on their behalf that an order for costs against the commissioners would have a chilling effect on the exercise of regulatory powers conferred on the police by the 2002 Act. And it should be noted right at the end at paragraph 78 of the judgment, which is page 1300, Lord Neuberger says, accordingly, for reasons which largely reflect those of Stanley Burton, LJ, and the Divisional Court, I would dismiss this appeal. So if, as appears to have been the case, there was a real concern about the chilling effect on the police, it is easy to understand why there was a focus on the issue whether the police had acted reasonably. But given the reference to chilling effect, we say it's fairly clear that the court as a whole was concerned by the chilling effect on the police. The last case in the series is the BT Ofcom case, and this is at page 1189. And I will refer to that and then see what the judgment of the Court of Appeal did below. So this is at 1189. The background, as the Court will know, is that Ofcom regulates the telecommunications market, and as part of this, it regulates what is called leased lines. These lines are connected to BT's fixed network and are used to provide millions of pieces of data, and these lines are provided by BT to wholesalers who then provide them to retailers in competition with BT. Ofcom is required to keep this market under review, and in 2016 conducted a 2-year business connectivity review. And if we go to page 1190, we see the Court of Appeal stating there, paragraph 2, that the decision concerned Ofcom's regulation of the business connectivity market. And we know that BT successfully appealed part of this review on market definition, and Ofcom was ordered to pay 50% of BT's costs. Ofcom successfully appealed against that order. Again, it is important in my submission to recognise the emphasis on the alleged chilling effect on Ofcom. If we go to page 1193 and paragraph 20, in the middle of the paragraph, we see seems to have been a key submission of Ofcom. In addition, however, Ofcom submitted that costs following the event starting point was inconsistent with the regulatory framework and risked having a chilling effect on regulation. And it's a chilling effect. And in this case, we see from paragraph 19 that Ofcom actually submitted a witness statement to this effect, which we have not had in this case. So we know that chilling effect was an issue in that case. If we go to page 1206, just to see what were the issues for determination. The review of the cases against the above somewhat lengthy background, the court needs, in our view, to consider three questions. The first is whether the CAT, the tribunal, has in the cost decision taken inadequate account of peripanathen and other cases, and the Court of Appeal says that the CAT had. And then importantly, for present purposes, that it's the third issue for determination. If either question is answered in the affirmative, that is to say, insufficient account of peripanathen, what is the consequence of any legal error made by the CAT in this case? And we see the answer to that, what is the consequence, of paragraph 84 at page 1210. This is the third issue that arose for determination. And we see what the consequences were. The Court of Appeal remitted the issue of costs back to the tribunal. The Court of Appeal considered that the tribunal was best placed to consider all the circumstances as the starting point, including, importantly, the chilling effect. Paragraph 86, in our judgment, the appropriate course is for this court to remit the cost decision to the CAT to decide the matter afresh on the correct legal principles adumbrated in this judgment. The CAT will itself be best placed to consider in detail the arguments on the chilling effect advanced by both parties, both sides before us. It will also be astute to ensure that in adopting a consistent, sustainable approach.
I mean, it's a slightly odd approach because clearly there hasn't been a chilling effect in this case because Ofcom took the decision and the appellant appealed. So it's neither side has been chilled in this particular case. So by remitting it, what were they expecting the CAT to look at? More generally, was it more generally whether there's a chilling effect in future cases and whether that should affect the starting?
Yes, I think that's right. Ms. Weitzman for Ofcom had put in a statement saying that adverse costs would have a chilling effect on its regulatory function. Now, whether that was true or not was remitted so that if Ofcom could prove that to the satisfaction of the tribunal, then in future cases there may be a different costs order. And it does indicate a certain hesitancy on my part because this chilling effect cannot easily slip off the tongue. There's got to be some substance to it. Otherwise, one is not going to exercise the discretion at all. So there has to be some substance to the submission by the authority. If you make an adverse costs order against me, it will deter me from making decisions. And that was clearly one of the issues that was remitted to the tribunal to determine. The important point from my purposes today, I'm not here to argue for or against Ofcom, but what I do submit is that was the reason, one of the key reasons for the Court of Appeal deciding as it did, which was that there appeared to be a risk of a chilling effect on Ofcom, and it had to be sorted out. Can I then go to the Court of Appeal in our case and how it dealt with the issue of chilling effect? This is at page 263 of the core bundle.
What's the precedent value of the CAT is a UK-wide tribunal, So does it follow the authority, the Court of Appeal authorities, the inner house authorities in Scotland, or does it follow the inner house authorities in England and Wales, or does it follow the ones in Northern Ireland?
Will have picked up, there is a divergence between Scotland and England and Wales as regards the solicitors' disciplinary issues. We see this from the Court of Appeal, and we can go to the, I don't think we need to go to the case, but there is clearly a difference in view between Scotland and England. And we did submit to the Court of Appeal that you do have to look at it in a broader church basis, and one cannot just say, well, apply Baxendale, that's the end of the matter, and that would apply to Scotland and Northern Ireland. So my Lord is absolutely right that when he's looking at whether a principle is just and not asymmetric or whatever is it a just principle, because that's what costs are there to do at the end of the day, one should be looking at how it would apply to Northern Ireland, to Scotland and England and Wales. And there is a tendency to say, well, Baxendale represents the law, and therefore it should be applied to the CMA, but the CMA, as we know, applies the decisions in Northern Ireland and Scotland. So that is why one has to a certain extent, look at, we say, the flexible, this is why I emphasised the flexible nature of Lord Bingham's principles and how Lord Justice Goldring described them as being flexible, not some sort of test. But the judgment of the Court of Appeal in our submission undoubtedly adopts a very uncompromising approach to costs. The judgment starts at page 263.
I think in the BT and Ofcom case, Court of Appeal did make the point, paragraph 65, that the CAT is a UK tribunal.
It did, yes.
And then went on to apply the English Court of Appeal authority without explaining why.
Well, maybe sort of slight tension between that and the decision at the end to send it back to CAT to decide.
Yeah.
But what the Court of Appeal did do at the end was foreshadowed in paragraph 6 as well, which is that it is the CAT is the specialist body and has to look at its own procedure, and if it's looking at its own procedure, clearly that it has an eye on more than just England and Wales. Given the time, can I go to paragraph 79 on page 285, because essentially that is why we are here. At page 285. This is the key paragraph, paragraph 79, which we say the Court of Appeal has set down the uncompromising cost rule to the detriment of successful appellants. Where a power to make an order about cost does not include an express general rule or default position, an important factor in the exercise of discretion is the fact that one of the parties is a regulator exercising functions in the public interest. That leads to the conclusion that in such cases the starting point or default position is that no order for cost should be made against a regulator who has brought or defended proceedings in the CAT acting purely in its regulatory capacity. And 345 is where we say the Court of Appeal starts to go really wrong. The default position may be departed from for good reason. The mere fact that the regulator has been unsuccessful is not without more a good reason. I do not consider that it's necessary to find exceptional circumstances as opposed to good reason. A good reason will include unreasonable conduct on the part of the regulator or substantial financial hardship likely to be suffered by the successful party if a cost order is not made, and there may be additional factors specific to a particular case which might also permit a departure from the starting point. So it will be seen that the fact that the authority has been unsuccessful is not a good reason to award costs against it in whole or in part, and there is no reference to undue financial prejudice or to chilling effect.
There's also no reference actually to the rule, the wording of the rule, and the provision which empowers the making of the rule, which I don't think actually is in the bundle, Section 15 of the Enterprise Act and Schedule 4.
The rules obviously are in the in Part 9 of the Enterprise Act, but yes, I mean, if 2 seconds, I'll come to the rules as well, because this uncompromising cost rule is inconsistent with the tribunal's rules. But just staying on this, there is no reference to undue financial prejudice or to chilling effect. Indeed, at paragraph 80, at page 285, the Lord Justice Lewison, does not understand why the Court of Appeal in BT Ofcom remitted the question of costs at all. Doesn't understand it. Not clear. And in my submission, the answer is pretty clear. It remitted so that an important issue of the chilling effect could be determined. We accept that the chilling effect on an authority is an important factor in deciding where the starting point is and whether any award should be made against the authority. If the tribunal is basically left with deciding whether the CMA has acted unreasonably, the chilling effect question has effectively been answered in favour of the authority. And put another way, proof of a chilling effect in practice adds nothing to the default position postulated by the Lord Justice. If the CMA has acted reasonably, the CMA does not need to show a chilling effect. If the CMA has acted unreasonably, a complaint about a chilling effect should fall on deaf ears in any event. So this lack of reference to undue financial prejudice or financial or chilling effect is a serious error, we say. And just to complete the picture, if we go to paragraph 100 at page 292, this is the passage where the Court of Appeal does not regard the chilling effect on the CMA as self-evident. This is paragraph 100. I would not regard the chilling effect on the CMA as self-evident. And then, lastly, at paragraph 107 on page 293, the Court of Appeal declines to remit the case because the tribunal has found that the CMA has not been unreasonable in pursuing the erroneous abuse point. So it means that the lack of any proof of any chilling effect is of no consequence. The bottom line is that the obvious practical result of this cost rule adopted by the Court of Appeal is that a successful appellant will have to prove unreasonable conduct if it is to obtain an award of costs. And in my submission, that proposition is not supported in the case law or on any principled basis, but it's not supported within the system of the Competition Act 1998, and in the time left, that is the third issue I would like to go to. So I do move to the last issue, which is the competition law context under the 1998 Act. And there are two aspects I wish to consider. First, the tribunal's cost rules relating to infringement decisions. And second, the nature of infringement decisions themselves. So I deal first with the cost rules, because these are clearly important. The rules are at page 1148. On 1148, we see Part 9 of the Enterprise Act. They're reflected in Statutory Instrument 2015, number 1648. They came into force on the 1st of October 2015, having been laid before Parliament on 8th September 2015. So they were laid before Parliament on 8th September 2015. Rule 2, we see on page 1148, has an interpretation provision. And if we go to page 1149 at the bottom, we see Rule 2, in brackets 2. It provides that the rules are to be applied by the tribunal and interpreted in accordance with the governing principles set out in Rule 4. And we'll come on to those in a minute. But I think it's important to realise that the rules are obviously squarely directed at the CMA as the public authority most concerned with their application. These rules and the cost rules have always had the CMA as the main respondent. Thus, the public nature of the litigation and the cost rules are not in any sense ancillary. The rules are intended to govern litigation between a private individual and the public authority. That is their purpose, to govern litigation between a public authority and a private citizen.
Although they do also, the same rule does apply to follow-on and standalone damages claims.
Absolutely, but to say that came later. The follow-on damages came later. I appreciate that Rule 104 came later as well. But when these rules were adopted, they clearly had appeals against infringement decisions as one of their key purposes. So it's not as if this is just a general discretion as to costs where a public authority happens to be defendant. It is designed to govern litigation between the private citizen and the public authority. And I think that is an important point to consider. Rule 3 makes it clear that the rules apply to appeals against the authority under Part 2. We don't have Part 2, but they set out the procedure that the parties, the authority and the private citizen, should follow on such an appeal. So I come to Rule 4. Rule 4 is important. This is on page 1150, because it sets out the governing principles. Rule 4.1 provides that the tribunal shall seek to ensure that each case is dealt with justly and at proportionate cost. Rules 4.2 sets out what these concepts include. Rule 4.2a ensures that both the appellant and the authority are on equal footing, ensuring that the parties are on equal footing. And Rule 4.2c provides that dealing with a case at proportionate costs includes considering the financial position of each party.
This is the same as the overriding objective in the civil procedure rules, isn't it?
It is. It is, in my submission, important, though, these are rules governing specific litigation between the private citizen and the public authority. It is, in my submission, important to recognise the principle of equality, and that must mean that the authority has no special status before the tribunal. No special status before the tribunal, unless there is some sort of objective justification. It means that in order to decide an appeal against an infringement decision, the authority has no special status. Parliament has directed that the authority and the undertaking should be treated equally unless there is a good reason. And this principle of equal treatment must be applied, we've seen this, when the tribunal exercises its discretion on costs under Rule 104. And Rule 104 is at page 1151. The court will have seen this as page 1151. Rule 104(2) confers on the tribunal a wide discretion to make such costs order as it thinks fit. And Rule 104(4) provides that in determining the amount of the costs a person should pay, the tribunal may have regard to the conduct of a party and whether a party has succeeded on part of its case, even if that party has not been wholly successful, and we know that reflects, again, the CPR.
It's rather odd, isn't it, because they don't actually deal with the party being wholly successful. It's basically because they've just copied out the CPR rule and cut out the bit about the general presumption in favour of the successful party.
That's right. Although when my lord is correct, but if one looks at 104(4)(c), and I appreciate that this is about quantum rather than the incidence of the costs, but if a lay person is looking at this and reading this and may take account of whether a party has succeeded on part of its case, even if that party has not wholly been successful, looking at the language, one might say, well, if a party has been wholly successful, it would be logical interpretation that they might expect all their costs, unless there is some other good reason. So if you're going to get a part of your costs, even if you have not been wholly successful, a person might say, well, if I've been wholly successful, I might get all of them, subject, of course, to the tribunal looking at all the circumstances. But in my submission, the uncompromising cost rule set out by the Court of Appeal at paragraph 79 does not take sufficient account of Rule 104. And in my submission, this must be the case whether or not Bradford's line of authority is applied or not, because it is common ground that the Bradford line of cases has to be read in the light of specific cost rules. So even if the tribunal cannot start with a costs follow the event, even if it can't, an issue-based cost order is not inconsistent with the Bradford line of cases viewed in the light of the rules. Where there is no real chilling effect, the rules give the authority no special status. The rules expressly envisage an issue-based order based on success. And in my submission, it's hard to reconcile that with the uncompromising cost rule adopted by the Court of Appeal. It's hard to see why such an issue-based order that was made below is a misdirection.
One sees 104(4)(d), which is a specific factor relating to offers for settlement. Is that in all damages claims or only collective ones, I think? Which are also mentioned in subparagraph 2, which shows that in some aspects of the tribunal's jurisdiction there has been specific treatment of a particular kind of jurisdiction which requires some amendment to the generality of the discretion.
Yes. And on that issue, there are two cases dealing with the dispute resolution. And I think it's important to see that the tribunal doesn't slavishly adhere to the costs follow the event. And so if we quickly go to those two cases, the two cases are basically BT and Ofcom. It always seems to be BT and Ofcom. But the first BT and Ofcom is called the RBS Backhaul Circuits case, and that's at page 1955. 1955. So do this very quickly, but it does show that the tribunal is prepared to adopt a pragmatic approach to costs. 1955. We see the nature of the issue at paragraphs 1 and 2. The tribunal at 2, for example, wishes to... This is essentially where the tribunal is sitting, or where the CMA is sitting in the middle, and the tribunal wishes to consider what is the right approach to costs in a regulatory field like this, where there are a real likelihood of litigation of one sort or another between these two particular parties. These are BT and Vodafone. This is, in a sense, part of the regulatory system, and in this particular case, the director was, at least formally speaking, adjudicating on a dispute that had been brought to him by Vodafone to resolve. And the bottom line is, and we can go to page 1970, is that the absent other circumstances, the tribunal is saying both parties will bear their own costs. So if BT is successful, BT will not get its costs. At 62, we see our judgment is that where Ofcom has determined a dispute in accordance with the procedure in the 1997 regulations and could have been appealed against by either side, it would not be right to order Ofcom to pay BT's costs in circumstances where Ofcom defended the appeal entirely reasonably and wider public interests were involved. 64, then our view is essentially the same if Ofcom succeeded. So if Ofcom succeeded, Ofcom would not get its costs. And we see the reference to the CPS Save activity case, and that is at page 1910, where the judgment was handed down on the same day because the tribunal wanted to give guidance on the issue of costs in this regulatory context. And the relevant paragraphs, I won't go to them, but the relevant paragraphs are 7 at page 1912, 28, 1918, and 37 at 1920. But this is where Ofcom succeeded, but didn't get its costs because the tribunal is saying, as part of the regulatory context, it should be cost neutral unless there are other factors which would suggest one party has to pay the costs. But this is a paradigm example of the Specialist Competition Appeal Tribunal monitoring the type of case before it, and in a true regulatory case, it is saying the costs should be neutral.
Well, it's not so much that it's a regulatory case. It's a case where the regulator is performing a quasi-judicial function.
Yes.
And that even though there are some procedures whereby the court or decision-making adjudicatory body ends up being the defendant or the respondent, unless they actively participate, they don't usually get their costs. Well, there's no order for costs against the High Court if the Court of Appeal overturns the High Court.
No, or an arbitrary, no.
But that's a different principle coming into play.
It is, but it does show that the tribunal is conscious of this.
I'm sorry, just on that, I wonder whether it's exactly the same, because in the sort of court cases where you have the magistrates' court, which may be formally the defendant, but in fact you have two underlying parties which are litigating against each other, the magistrates' court, or whatever the court is, simply drops out of the picture and plays no role at all, although in a regulatory appeal, as I understand it, Ofcom, say, will be an active participant in defending the proceedings. Is that right?
It does, yes.
So there's a limit to that analogy.
There is a limit to the analogy, and that is why there was this issue: should BT get its costs if it succeeds? And Ofcom has defended it, but and I think that's why it was important to see in the RBS case that the tribunal was regarding it as part of the process of regulation. And the reason I think that is important is because, by contrast, in infringement decisions, for over 20 years, the tribunal has taken a different approach. The tribunal considers in costs that all circumstances are relevant. One only has to look at the tens of cases before this court. All circumstances are relevant, but does not shy away from awarding successful persons their costs when they're defending themselves. And there are two cases that, given the time, I would wish to go to just refer to two last cases on infringement decisions. The first is the GISC case, that's G-I-S-C, the GISC case at page 1233 of the bundle. On the bundle. Thanks, love. Put it somewhere.
I'm not sure if it's helpful. There is a bundle under your lectern. I don't know if that's where it's disappeared to.
No,
all right. I'm trying to be helpful.
well, that's the key authorities bundle. Strange. Anyway, something had to go wrong at some point. Page 1233. This is the GISC case. And I would emphasise paragraphs 56 and 57 at page 1248. Clearly, there are other relevant passages here, but I do rely on paragraph 56 and 57 because the tribunal is referring to certain considerations relating to infringement decisions which take the CMA and its adoption of infringement decisions out of, essentially, the regulatory context of the cases we've been looking at. And when it comes to infringement decisions, the tribunal referred to three basic factors, which we see from 57, as to why an issues-based cost order is appropriate. First, there must be a consideration of fairness to the individual whose rights and obligations are affected by wide-ranging and draconian powers. Second, the costs of the administrative procedure are not recoverable. So by the time of the appeal stage, the undertaking will have already incurred an element of costs. And third, and importantly, the tribunal's powers to award costs constitute a counterbalancing element in the system and imposes a necessary discipline, uses the word discipline, on the authority or on the parties. And this counterbalance in infringement decisions has been an important consideration for the tribunal for over 20 years. And that is why, if we go to the last case, Eden Brown, at page 1221, paragraph 16, the third line down, Mr. Justice Roth, who, as we know, is a very senior competition law judge, did not regard infringement decisions adopted by the CMA as, in quotes, remotely comparable to the...
Which paragraph's that? I'm so sorry.
Paragraph 16, 1221. This is Mr. Justice Roth. The imposition of sanctions for breach of Chapter 1, Chapter 2 under the 1998 Act, which constitute criminal penalties for the purpose of Article 6, cannot be regarded as remotely comparable to licensing decisions. And in my submission, that has to be given a good deal of respect. And infringement decisions are in a different category in my submission to other licensing decisions and regulatory decisions. They are targeted at individual companies, not at a market in general. The CMA does have very draconian powers. It has the power, as we know, to seize computers, phones without warning. It has the power to eavesdrop, covert intelligence. It examines hundreds of private emails and texts relating to the person concerned. An infringement decision may lead to the company directors being disqualified, as we've seen, and the decisions are binding as to liability for follow-on actions for damages. And as we've seen this morning, the CMA's board of directors is assisted by a team of in-house lawyers and economists. And the infringement decision is adopted after a statement of objections which imposes non-recoverable costs on the person concerned right from the beginning. And the decision is targeted at showing that the company has broken the law. We know these complex decisions run to hundreds of pages. In my submission, it's plain as a pikestaff that any infringement decision forces that private person concerned to spend money in its defence. And if the private person is to have any chance of mounting a defence, it must incur the cost in rebutting the legal and economic case advanced by the CMA, who, as we've seen, is already well equipped with a legal team and expert economists. Given those considerations, in my submission, the system provided for by the 1998 Competition Act and the cost rules militate in favour of an issue-based cost order which reflects the private party's success. That is not to say the tribunal ignores all other factors. It certainly doesn't. If the CMA effectively forces the person concerned to spend money to defend itself, and that person does so successfully, we say there is nothing unjust about allowing the person to recoup some of the money spent in its defence. And this is so particularly when the CMA's litigation costs are effectively bankrolled by the considerable fines it imposes. The cost rule, advocated by the CMA and endorsed by the Court of Appeal, for all intents and purposes, prevents that person from recouping any of its costs. It prevents the person recouping costs unless that person can prove that the CMA has acted unreasonably or there is substantial hardship, both, in practice, very difficult conditions to satisfy. In my respectful submission, that is an unjust rule, it is an unequal rule, and it should not actually reflect the common law. Those are my submissions, and thank you for listening. No questions.
Thank you very much.
I think Mr. Jar wants to do some musical chairs and change places.
Yes. Well, the court will take the opportunity to adjourn for 5 minutes while you do so.
Thank you.
Yes.
May it please the Court, on behalf of Flynn Pharma, I gratefully adopt the submissions of Mr. Brearley. I will endeavour to supplement rather than to repeat what he has already said.
Well, we're grateful for that.
Inevitably, there may be some overlap, and hope that the Court will bear with me if we want to put some of the points in our own way. But with the Court's permission, I intend to structure my submissions as follows. First, by way of introduction, I plan to break down what we say are the essential issues in this case, and then to identify what we say is the correct approach to those issues, and also what we say are the key errors with respect on the part of the Court of Appeal below. After that, I plan to make some observations about the effect of the particular procedural rules of the CAT, and to take you to the underlying judgment of the CAT at first instance, and to some of its reasoning. And we will submit that when one looks at those in combination, the rules and the CAT's judgment, they actually provide a very short answer to at least one of the issues that is before you. And then finally, I intend to come back to some of the case law, both of the High Court and of the CAT, that has been referred to by the Court of Appeal and by the CMA in its written case. And in the course of dealing with certain of the CAT cases, I also intend to touch on some of what we say are the key issues of public policy that determine the issues in this case. So turning then to the issues before the Court, we say there is a specific issue, and there is also, underlying that, a general issue. The specific issue, of course, is what is the correct starting point, or the default position, in the CAT in relation to costs, where there has been a successful appeal against the CMA, in whole or in part, from a competition law infringement finding. The judgment below says, and the respondents say, that the starting point must always be no order as to costs, and we say, with the CAT tribunal below and with many previous CAT tribunals, that the starting point may be that the successful party is entitled to recover its costs, at least in relation to those issues in which it has been successful. So that is the specific issue. But underlying that issue is a more general one, and that is, what is the proper approach to the incidence of costs in successful appeals against decisions of regulators more generally? So any regulator or public authority in circumstances where there is no specific provision that costs follow the event in the relevant procedural rules. And we thought it would be helpful if we were to summarize for the court what we respectfully invite its approach to be in relation to that more general issue. May I start by clarifying what we say we are not submitting in relation to that general issue? We are not submitting that there is any invariable presumption that costs must follow the event. Equally, we are not saying that there can never be circumstances in which the appropriate starting point in relation to a successful appeal against a regulator's decision is no order as to costs. Those are what we don't say. What we do say can be boiled down to essentially 5 propositions. First of all, we say that what is the proper starting point, or the default position, is a matter that should be determined on the basis of the particular regulatory and legislative context and in light of any indications in the particular procedural rules. There is no universal answer to the proper starting point that can or should be applied across the board. The proper starting point can and should be determined without any presumptions or assumptions in one direction or another. What does matter is that the appropriate factors are taken into account in arriving at the right starting point. Our second proposition relates to what those relevant factors are. And we suggest that there are at least 2 factors that should always be taken into account. Now, by that I mean that they should always be considered. That doesn't mean that they will always be present or of great weight. And we've described these in our statement of case as mandatory relevant considerations. The first of these is whether a starting point of no order as to costs against the regulator would, by creating financial prejudice to the appellants, operate to deter meritorious appeals. Now, that is likely to be a particularly potent factor when, in circumstances where the regulatory decision is in error, there is likely to be a public interest as well as a private interest in the correction of the erroneous decision. In other words, whether the decision in question is likely to have ramifications or effects on persons other than just the individual appellant. And as I will go on to develop, that is an important point in the present context, because we say there is a clear, wider public interest in the correction by the CAT of any erroneous infringement decisions on the part of the CMA. So that, if you like, is the chilling effect, potential chilling effect on the appellant. Another of the 2 mandatory relevant considerations is we accept, like Mr. Brearley, is whether in the particular legislative and regulatory context that a practice of making adverse costs orders against the regulator when it's unsuccessful will be liable to create a deterrent effect on the particular regulator from taking and standing by reasonably made decisions. Contrary to the CMA's position, we don't accept that it should simply be assumed that every regulator will be deterred by the possibility of a costs awards against it if it gets it wrong. It is a matter that requires evaluation in the particular case. So that's our second proposition. Our third proposition is that even where a potential chilling effect on the regulator is identified, that is not, as it were, a trump card. In arriving at the proper starting point, that factor must be balanced against any potential deterrent on the appellants, which I've mentioned already, and indeed against all of the other relevant factors, some of which Mr. Brearley has already mentioned, such as the desirability of encouraging discipline in litigation, or the unfair overall cost burden on appellants in light of any prior administrative proceedings, and so on. The fourth proposition, and this is a point, I think, of rare common ground between ourselves and the respondents, is that we do accept that it is certainly permissible and at least usually desirable for courts and tribunals to establish an appropriate starting point in relation to the instance of costs for any particular type of appeal before it. Now, possibly contrary to this, one of the interveners in the present case, Oak Ridge Farms, has cited the dictum of Lord Lloyd in Bolton MDC and the Secretary of State for the Environment, and the famous quote that in questions to do with costs, the fundamental rule is that there are no rules. That's paragraph 4 of their submissions in the key bundle at page 174. Now, we accept that up to a point. And as the CAT has said on several occasions, what it calls a starting point must always be seen as no more than that. It's only guidance which can be departed from in the particular circumstances, and it is not the same as a rigid rule. And in addition, we don't completely exclude the possibility that at least in some rare cases, it may be appropriate for there to be no starting point at all. But as a general matter, we do accept that it is desirable to have starting points or guidelines, even when it comes to costs. And that's because they provide litigants with predictability, and they ensure a degree of consistency, and in that way, fairness. They're also, of course, of convenience to the tribunal, because they don't have to identify the correct starting point entirely afresh on each occasion. So we're not against starting points. The final aspect of the approach...
Well, sorry, I think one can add to that, they may help the parties to negotiate and settle without having to trouble the tribunal at all.
I may say so, that's a very, very good point, yes, absolutely. The final aspect of the approach that we advocate concerns the identity of which tribunal is best placed to weigh the factors and make the assessment as to what is the proper starting point. And we submit that that is the specialist supervisory tribunal itself, in this case, the CAT. That is the tribunal that is best placed to assess where the overall public interest lies. And that's based on the experience and expertise that it has in the type of proceedings in question. They are better placed to know how things work on the ground. And higher courts who are further removed should leave it to them and shouldn't second-guess their assessments unless they've made an error of principle or clearly got it wrong. As the Court of Appeal in BT and Ofcom said at paragraph 64 of its judgment, with respect entirely rightly, tribunals should be masters of their own procedure. Now, even if it is held that the specialist tribunal has failed to take into account relevant considerations or taken into account an irrelevant consideration in setting the proper starting point, the proper course is usually not for the appellate court to take it into its own hands, as the Court of Appeal did in this case. It would, if that conclusion were reached, the proper course would be to remit the matter back to the specialist tribunal for reconsideration, just as the court did in the BT and Ofcom case. So that is a summary of the approach that we respectfully commend to the court. It's not an approach that we can claim any great novelty over. It is, in our submission, consistent with Lord Bingham's principles, perhaps a slight elaboration on them, and it is by and large the approach that the CAT has developed over the years, and it's also, we say, actually consistent on a careful analysis with the approach that's largely been adopted in the High Court and the Court of Appeal, until at least the present judgment under appeal. And that brings us to that judgment. Now, the approach of the Court of Appeal to the general issue that I've identified is rather different. And you've seen it encapsulated in paragraph 79 of the judgment, which Mr. Brearley has already taken you to. The Court of Appeal's approach is that where there is no express rule that costs follow the event, and there has been a successful appeal against a decision of a regulator acting in a regulatory capacity, the default position or the starting point is always no order as to costs. And the burden is then thrown onto the appellant to show some particularly good reason why that starting point or default position should not apply. And one factor that can never suffice to mean that it should not apply is success in the action, whether that's in the whole case or on an issue. As to what reasons would suffice, they certainly seem to be very few and far between. We're told that unreasonable conduct would suffice. We're told that serious financial hardship might suffice. But beside those two examples, nothing else has ever been mentioned. Though it appears that if there are good reasons, they are highly exceptional. Now, what is striking about the Court of Appeal's approach to this, and in our submission novel and with respect wrong, is that it requires a uniformity of approach regardless of the particular regulatory and legislative context. And in doing so, it omits any prior stage of inquiry at which the relevant court or tribunal asks itself, in light of all the particular regulatory and legislative context, and by reference to all relevant factors, including the deterrent on the appellant, what is the starting point on costs that would best serve the public interest? The starting point is preordained. Now, one can see that that uniformity gives it the attraction, perhaps, of simplicity, but it is also, in our submission, flawed, and it's flawed for three main reasons. First, the Court of Appeal's approach is entirely founded, as you've seen, upon the public policy objective of ensuring against the potential chilling effect on the regulator. And that is, we accept, an entirely legitimate public policy consideration. But whether such an effect is liable to exist at all, and certainly whether it's liable to be significant in its effect or in its extent, will surely depend on the particular regulatory context. And there are some regulatory contexts where it is just not realistic that the regulator is going to be materially deterred from reaching the relevant decision by the prospect of a costs award against it. And this is one of them, as Mr. Brearley has very persuasively, in my respectful submission, shown you. There really is no plausible chilling effect in the present context. But on any of it, and on any view, there are going to be regulatory contexts where the risk of a chilling effect is greater and those where it is lesser. On the Court of Appeal's approach, and indeed the CMA's approach, none of that matters, because it's not a matter that's to be assessed. As the CMA put it in their statement of case at paragraph 86, they say it is regarded as an inherent risk in the case of any regulator or public authority. And it is not, they submit, a matter to be resolved by evidence. In other words, it's just to be assumed on their case. And the drawback with that, the very obvious drawback, is that the approach to costs becomes completely detached from the only public policy consideration that is said to justify it. It becomes completely untethered. But there's more to it than just that, because the other difficulty is that it elevates the chilling effect on the regulator above all other factors. But there may well be many other factors, even where a chilling effect exists, that may individually or collectively mean that a different starting point is more in accordance with the public interest. And as I've said, one of those other factors that may well outweigh it is the deterrent effect on appellants. And we say there's no sound basis for elevating the chilling effect on the regulator a priori above all other factors. And finally, of course, what the effect of the Court of Appeal's approach is to diminish the role of the specialist tribunal. For no longer is the specialist tribunal able to set the starting point. The starting point is imposed on it from on high. Now, that's all I wish to say by way of introduction to the issues. If I could turn next to the procedural rules and to the CAT's judgment, because they do provide a rather short and easy resolution to what I called the specific issue in the case. Now, Mr. Brearley has already taken you to the CAT rules. They contain, in our submission, at the very least, a very clear indicator, both that it is permissible and within the discretion of the CAT to make an order for costs based on the success on an issue or issues, and also that it is contrary to the principles of the CAT to place the parties on an unequal footing. I just make one or two further observations about those rules, if I may. One is that one has, of course, the general provision in 104.2, which is the power to make whatever costs order the tribunal thinks fit, which confers a very wide discretion on the tribunal. And that is identical both to the previous CAT Rule 55 in the old CAT rules of 2003, and it's also broadly identical to the procedural provisions that are considered in the various High Court cases, Baxendale, Walker, Perrin-Panathan, and so on. But the two specific provisions that we rely on, 104.4c, which is the provision envisaging issue-based costs orders, and Rule 4, which ensures that the parties are on an equal footing, those are new to the 2015 CAT rules. So we say it is significant that a deliberate legislative choice was made to include these two provisions. Now, I don't say that they changed things as far as the CAT's practice is concerned, but that's because what they were really doing was codifying that prior practice of the CAT that had developed through its case law.
I think there was a public consultation exercise on the 2015
I think that's absolutely correct.
John Mummery's report.
Yes.
Was there anything, has somebody checked that there was anything useful about costs?
I confess I don't know whether it's been checked. We'll need to look into it.
It might be useful to know.
Yes. But it is in our submission effectively codifying what was going on before. And it is significant in our submission that there's also no equivalent to those specific provisions in the equivalent costs rules in the prior cases considered by the Court of Appeal in Baxendale, Walker, or Perrin-Panathan. So we say that these particular procedural rules contain a clear steer, putting it at its lowest, against the CMA's approach. Now, if I may then, against that background, show you what the Court of Appeal said about the CAT judgment. That's in, it's at paragraph...
Sorry, just before we move on from this, do we have the old Rule 55 in the bundle?
I don't think we do, sir.
All right, well, perhaps if that could be supplied, just if we're asked to compare and contrast.
Yes, of course.
And if the consultation paper could also be looked at to see what the genesis of the change was to introduce Rule 104.2c.
My Lord, we will do that, and if we may, we will get back to the court in due course.
And if we're having requests, I'd also like the Section 15 of the Enterprise Act and Schedule...
Yes, indeed.
Is it Schedule 4, which is referred to?
My Lady, which forms the basis for the statutory instruments that are
yes,
that contain
it's the power that the Secretary of State was exercising.
Yes, indeed, of course. Just before we come on to the CAT's judgment and how the Court of Appeal characterised it, it's suggested by the CMA in its written case that Rule 2A is a general principle for the guidance of case management decisions. That may well be so, but it is also, of course, no less applicable to questions of costs. Indeed, in the supplemental bundle of authorities, which is just, in fact, it is just one authority that we've provided the court with, there's a recent Court of Appeal decision, McCowan and Langer. I don't propose to turn it up, but in paragraph 39 of that judgment, the Court of Appeal observes that the equivalent provision in the CPR that refers to the parties being on an equal footing is indeed applicable to costs, just as one would expect. So both of the provisions that we rely on are fully applicable to matters relating to costs. If I could just show you briefly, I was about to go to the Court of Appeal's judgment below, and just to show you how they characterize what the CAT did. It's at paragraph 4. It's in tab 10 of the key documents bundle at page 232. And what they say is that they say this. Following its decision on the substantive appeal, the CAT considered the question of costs. In its ruling, it held that the established practice of the CAT in appeals of this nature was that the starting point for the exercise of discretion was that the unsuccessful party should pay the successful party's costs. I refer to this starting point as costs follow the event. It considered the decision of the court in BT and Ofcom, but decided that the decision in that case didn't require a different starting point. From that starting point, the CAT considered who had won and who had lost on the various main issues. Its ultimate ruling was that the CMA should pay a proportion of the costs of both Flynn and Pfizer. Now, in our respectful submission, that's not a wholly fair summary of what the CAT actually did. Could I dip into the CAT's judgment a little to show you that? It's at tab 12 of the Key Authorities bundle. If one goes to paragraph 29 of that, which is on page 277, one does indeed see that in paragraph 29, it concludes, starting from the third sentence, it says, "We see some force in the CMA's submission that this case is one in which there is no binary result, particularly as we have remitted the issue of abuse to the CMA for reconsideration. Nonetheless, in our view, it cannot fairly be said that there is no winner in the case in circumstances where Pfizer and Flynn have succeeded in having the CMA's finding of abuse and, in consequence, the penalties imposed on them, set aside on the grounds that the CMA made serious errors of law and assessment." So it is right that the CAT does conclude that the overall winner were the appellants, as the CMA had made serious errors of law. But what the CAT then ultimately does is not to make an order that costs follow the event. It doesn't make a winner-takes-all order. It very specifically makes an issue-based order. And if I could show you that, it's at page 283, starting at paragraph 53.
I think
Yes.
my numbers in the paper bundle, page numbers are...
They're not the same.
They're not the same.
No.
So where are we?
Paragraph 53 of the CAT's judgment.
Mine is the same.
You don't have an electronic page number, do you?
Sorry, paragraph
312. Thank you very much indeed, Sir James. 312.
Paragraph 53. If I may, is it convenient for me to proceed, my lady?
Yes.
Paragraph 53 says this. It says, "We must now consider the CMA's further submission that there should be an issues-based approach. That is to say, one that takes account of the extent to which each party has been successful on different aspects of the case. Pfizer and Flynn object to this approach. But it seems to us that this is clearly appropriate in this case, given that the respective successes and failures of the parties present a mixed picture overall. We have well in mind that the tribunal rules permit us to take into account whether a party has succeeded on part of its case, even if it has not been wholly successful, Rule 1044C. So, just pausing there, the CAT is expressly relying on and referring to this provision. Then it says this in 54, we do not accept Pfizer and Flynn's submissions that as clear winners they should be entitled to recover all of their costs. The CMA successfully defended the grounds of appeal in relation to market definition and dominance. While Pfizer and Flynn succeeded in having the findings of abuse set aside, they were in fact unsuccessful on the majority of their grounds of appeal, and the issue of abuse has not yet been determined, but has rather been remitted to the CMA. And then they say, 55, whilst overall success is obviously important as far as the appellants in this case are concerned, it remains the case that very large sums were incurred in respect of grounds of appeal that were ultimately dismissed or not required to be decided by the tribunal. The market definition and dominant grounds took up a significant part of the hearing, as did certain of the grounds of appeal on abuse on which Pfizer and Flynn were ultimately unsuccessful. So the CAT...
Was the result of the decision on the substance the setting aside of the fines?
Yes, it was, my lady.
But has that been remitted?
The whole issue, because it was a setting aside on abuse and therefore on the fines, but not on dominance.
Yes.
So,
yes, the companies were in a dominant position, but they didn't abuse their position because they wasn't found on the basis of the CMA's methodology.
Yes.
It wasn't found that they'd abused their position.
Indeed, Madam.
Because they hadn't used a comparator technique.
That's exactly
where it says at the end of paragraph 54 that it's been remitted.
Yes.
So there is the possibility that there will be...
There is the investigation goes on.
Right, but that will be then a different fine imposed if there is a finding of abuse.
Yes, indeed.
Right.
My point is a very straightforward one, which is they don't take a costs follow the event approach. They take an issues-based approach. And if one goes to then on to paragraph 64, I don't think which is 2 pages on, I don't think I need to read them out, but what they do is to say, effectively, they say, well, they say that it's right that that effectively Pfizer and Flynn should get their costs in respect of abuse, and the CMA should get its costs in respect of market definition and dominance. And they say that it appears to us that on a broad brush basis, it's fair to say that approximately a third of the assessed costs should be deemed to relate to market definition dominance and 2/3 to abuse. And then what they do is to say, well, we could have made cross orders, this is in paragraph 65, for costs payable by each of Pfizer and Flynn and the CMA, which would then have to be set off against each other. But we find it easier to make a single order for the CMA to pay a proportion of the costs of Pfizer's and Flynn's appeals and to reflect the parties' varying fortunes in an overall deduction from Pfizer and Flynn's maximum recoverable costs. So this is just a plain mutual issue-based costs award that is simplified to avoid separate orders. And so stepping back, we say this is just a very straightforward application of the procedural rules and comfortably within the exercise of the tribunal's discretion. How can it conceivably amount to an error of law? And the only answer to that, given by the CMA, is to summon the Court of Appeal's unwritten common law rule that is somehow more potent than the terms of the statutory instrument. And we say it would be a most unusual for an unwritten common law rule to be privileged above a factor, success on the issue, that is expressly mentioned in the relevant procedural rules.
Is there any reference in that decision to chilling effect?
My lord, there is, and what effectively there are submissions made on chilling effect. One sees that at paragraphs 16 to 17, and it's apparently made by both sides. We see Pfizer claims that there would be it says, as to the alleged, in paragraph 16, Pfizer says, as to the alleged chilling effect of awarding costs against an authority, Pfizer says the reverse is the case, and not awarding costs would inhibit companies from appealing wrong decisions, a point that I will come back to.
It might be said that they ought to have considered those points and decided whether they made a difference. I mean, it's a bit hard to follow why they just said, well, we don't need to take account of them at all.
Well, they do say on paragraph 46 that they, as your lordship says, that they don't consider the need to consider the parties' arguments on any possible chilling effect. We are inclined to defend the CAT, however, on this, and the reason that we defend the CAT in not if considering a chilling effect is because this is a matter that has already been considered in the prior case law, in JISC and in Eden Brown. And so we don't think that it's necessary unless there's some change of circumstance. Right. It's surely not necessary for the CAT to reconsider the proper starting point on each separate occasion. Otherwise, the starting point would really have little.
Do we know, perhaps this is a question I should have asked Mr. Brearley, but do we know when this arrangement with to the deductibility of the costs from the penalty income, when that was arrived at? Has that always been in place with the...
My lady, I do not know.
When the CMA took over from the OFT?
My lady, we will need to do our homework on that. But precisely when
you may be able to ask your colleagues on the other side of the court. They may have easier access.
They will have to do their homework as well. My lady, I see the time. I don't know if that is my lord, if that's a convenient moment.
That would be fine. The court will now adjourn.